Good evening and welcome to our session on estates and wills. I'm Kapish Singh from the Professional Providence Society, and I will be your host for this evening. We are here to answer any questions you may have and ask that you please refrain from using the raised hand function, but rather type your comments and questions in the Q&A tab. We will respond to the questions once we have concluded the presentation. CPD certificates will be loaded to the SADA platform, and you will be able to access your certificate under your member profile. If you are not a SADA member, you will be able to create a profile for yourself and access your CPD certificates. The event tonight qualifies for one clinical CEU. We are streaming live on YouTube also, just in case you have difficulty accessing the Zoom platform. I would also like to remind and notify you of an upcoming webinar. On the 7th of October, we have the SADA SASO evening with Dr. Mark Vertemeyer and Dr. Noland Naidu. PPS and SADA are committed to empowering our members through education. We would like to thank those of you that have attended the previous PPS financial education presentations. And as per the feedback received, I'm very happy to announce that beginning tonight, we will be rolling out an accredited financial education session every month till December 2021 on topics that you have highlighted. So please watch this space. Should you wish to be contacted by PPS, kindly note that we will be sharing contact details at the end of the presentation, but you're also welcome to drop us a note with your details in the Q&A tab. I would now like to introduce our speaker for this evening. Tamsyn Gradwell began her work journey in the accounting and auditing field as an assistant accountant and audit clerk. Her financial advice journey began in 2011 when she started as a financial planner. In 2016, she began as a business development consultant for Nedgroup Trust and Old Mutual Trust. Her focus areas are estate planning, business continuity and succession planning, risk planning, and holistic financial planning. So without further ado, Tamsyn, the proverbial floor is yours.
Thank you. Thank you very much, Kapish. Thank you for that lovely introduction. I am very happy to be here with everybody on Zoom this evening. I am going to take you through a estate planning and wills presentation. It will be like a lecture, but we would like you to ask as many questions as you need to ask, and we will address those questions at the end of the session. All right.
Yep, we're good to go.
We're good to go. Wonderful. Yeah. Thank you. All right. This evening, we'll be talking about creating your legacy and how you can do that through estate planning and wills. The outcomes of this evening session is that we would like you to have an understanding of the different types of succession. There we go. The requirements of having a validly executed will, the role and responsibilities of an executor, important considerations for children, the role and requirements of having a living will, the implications of not having a valid will, the consequences of the different marriage regimes, and then finally, steps to get your affairs in order. Okay. All right, there is a common misperception that death happens to other people and that your turn is a long way off. People sometimes fail to appreciate the seriousness of matters, and they don't always apply their minds to personal affairs. You either put it off or you forget to draft a will. And then some people take the execution of a valid will and the drafting process thereof very lightly. It's not sufficient to fill out a standard application form, an online form, or acquiring a draft will at a retailer. And then we have some people who think that they themselves can are sufficiently competent to draft their own will. And then lastly, most people fail to appreciate that the drafting of a will and the putting into place of a succession plan and a tax plan are highly specialized areas of law. Okay. Next, we'll be talking about the different types of succession. We have testamentary succession. That is where you have exercised your right to have a valid will. We have the law of interstate succession. That occurs when a person dies without having exercised their right to have a valid will in place. And then lastly, we have contractual succession, and that you can do via an antenuptial contract. There are many good reasons for having an up-to-date and valid will. That includes your ability to choose your executor, to choose the trustees of a trust if you're creating a testamentary trust, to choose who you would like to inherit your assets, to make use of the various estate duty, tax concessions and deductions, to negotiate executor's fees, as well as to include special instructions and directions in your will. The freedom of gestation is the freedom to execute a valid will and to determine which assets will be distributed and to which beneficiary. In South Africa, we all have the freedom of gestation. Who can make a will? You must be over the age of 16 and over. You must be mentally capable of appreciating what you are doing when you have a will or when you are drafting a will. Another form of saying that is that you should be competent to give evidence in a court of law. The will must be signed by you as well as 2 independent witnesses. And although not a formal requirement in terms of the Wills Act, ideally the will should be dated so that there's no question about whether or not that is your last validly signed will. Who is the executor and what does the executor do? This is a question that is often asked with regards to executors and what their job is and how long it takes to wind up an estate. One of the very first things that an executor would do or an estate administrator would do would be to sit down with the heirs and not to read out the will like we see in the movies, but to start by taking what we refer to as taking in the estate. And that would be to help the heirs to complete the inventory. The executor, the administrator needs to know what assets they will be dealing with. In that meeting, it's also possible to go through the original will and make sure that the original will is going to be reported to the master's office. And then the process starts of applying for the letters of executorship, which is issued by the master of the High Court. And then once the executor receives that letter of appointment, they can start the process of administering the estate. Administering an estate can take anything from 6 to 12 months and longer, depending on the complexities involved, as well as other circumstances that could lead to delays. One of the things they do is they would notify the creditors and debtors that the person has died, and they would open a bank account in the name of the deceased estate. Then they would determine if the estate is solvent, meaning if there's insufficient assets to cover the liabilities, and determine the value of the assets and liabilities. They would then select a suitable way to liquidate assets if needs be, make sure that all estate debt is paid, prepare the liquidation and distribution account, which is basically the estate's financial statement, and that needs to be submitted within 6 months of having received the letters of executorship, formal letter authorizing them to administer the estate. And then for a period of 30 days, the estate account will lay for inspection. And then lastly, final step, the whole point of the exercise is to distribute the estate or the assets to the heirs. The important documents that an executor would need to start the process would be the normal documents like your ID document, marriage certificate, copies of an antenuptial contract, any divorce orders that are applicable, copies of firearm licenses, vehicle registration certificates, title deed to properties, details of the heirs. Each heir would fill in a form with their personal details. The short-term insurance policy schedule, I have experience of where you can find a lot of information from the short-term insurance policy schedule, bank statements, timeshare certificates, share certificates, details of any debt that the deceased had, as well as their income tax details. The executor will also require these documents if there is a surviving spouse and where they are married in community of property. And we'll get to the effects of marital regimes at a later slide. I'm getting to the slide where we've spent quite a lot of time on this evening. It's with regards to children, referred to as minor children, children under the age of 18. One of the problems when it comes to the inheritance of children is that technically they cannot inherit. They can own an asset, but they need the assistance of a legal guardian to be able to manage or control that asset until they are of legal age to do so. One of the important things in your will is that you can nominate a guardian for your children who are under the age of 18. All parents are natural guardians of children, all biological parents or legally adopted parents. So when it comes to simultaneous death or where there is a single parent household, nominating a guardian in the will becomes extremely important. So in a will, you would have a clause that states, failing a natural guardian, I hereby appoint Peter as the legal guardian of my child. However, parents with children must apply their minds when they are considering the appointment of a guardian in their will, because that guardian would be the person to look after the physical person of the child, as well as the inheritance of the minor child, if trustees have not been nominated. So you must consider and appoint a fit and a proper person as guardian of your child. Firstly, the person must be willing to accept the nomination because it is such a serious and an onerous duty to undertake. They need to consider the financial ramification and changes to their lifestyle, as well as their existing family. You should consider the location of the guardian. It would not make sense to nominate a person who lives in Canada and you live in South Africa. And then trust is obviously very, very important when it comes to your selection of guardian for your children. So ideally, you should appoint a guardian in your will. The nominee should have a conversation with the guardian. The nominated guardian should agree to the appointment and also be made aware of the steps that they would need to take if you were to pass away. So the court is the ultimate guardian of children who are orphaned. The court will decide what is in the best interest of the child. Before they grant guardianship to your chosen alternative guardian, they will look at the relationship of the nominated guardian to the child. They will look at, for example, the location of the nominated guardian and any other factor that in the in the opinion of the court, should be considered. Inheritance left to minors is an issue that is dealt with in the Administration of Estates Act. Because minors technically have a legal disability when it comes to inheriting assets, there are provisions in the law that protects minors' inheritance. It aims to protect a minor's inheritance. A minor or a child, I'm going to stop referring to minors as minors, it's children. Children cannot be given their inheritances. The natural guardian of the child is entitled to receive from the executor any movable property. So, for instance, jewelry or furniture to which the child is entitled, and to hold that on behalf of the child. But the executor cannot just give a sum of money or any movable property to the child's guardian unless the will itself directs them to do so, or where the person has provided security or was not provided security to the satisfaction of the master. Otherwise, the executor is obligated to pay any cash over to the to the guardian's fund. And any movable property would have to be sold and the proceeds paid over to the guardian's fund. When it comes to immovable property, like a house, a child is entitled to the property. They can own a property and it can be registered in their name, but it can't be mortgaged, can't apply for a bond on the property, can't be sold without the permission of the master of the court. The guardian's fund falls within the administration of the master of the High Court. Each master's office has its own guardian's fund. The fund is akin to a trust that creates and that is created to hold and administer money which is paid to the master on behalf of children, unborn heirs, as well as any people who are incapable of managing their own affairs. The process with regards to paying money over to the guardian's fund is that the executor would deposit the money over to the guardian's fund. The master's office would open an account in the book of the guardian's fund in the name of the child to who the money belongs to. The money in the guardian's fund is invested with the PIC, the Public Investment Commission, and is audited annually. The money in the guardian's fund earns interest, and the master administers the funds free of charge. There's no admin fees paid by the account holders. However, it's not always ideal because these funds are not easily accessible and are usually invested at below market interest rates. When it comes to the inheritance of minor children, it is almost always advisable to rather create a testamentary trust in your will and nominate capable trustees to administer funds on behalf of your children. All right, another topic that is often brought up in practice, and that is the living will. A living will is different to a testamentary will in that it guides your family and doctors when you are not in a medical state from which you cannot recover, and due to your condition, you are no longer able to make your own medical decisions. So a living will, although there's no legislation specifically dealing with living wills, to be ethically valid, you must be 18 or older to have a living will. You must have mental capacity to make your own medical decisions at the time of issuing of the directive. And you must be satisfied that the patient, as a doctor, didn't change his or her mind after the directive is issued. And the patient may only refuse consent to treatment if they have been fully informed about their condition and proposed treatment. Before I go on to the next slide, I just want to comment further on a living will. A living will ideally should be held with your medical practitioner. There are attorneys who draft, who specialize in the drafting of living wills. And it is something that you can make mention of in your last will. However, as I mentioned, a living will deals with a medical emergency or where you are not in a medical state to make decisions about your body. All right, we've come to the implications of not having a valid will, and that is dealt with in the Interstate Succession Act. All right, so without a will, you can expect that there could be potential delays in the winding up of your estate. The law will have to determine your beneficiaries because you fail to exercise your right to nominate beneficiaries. The law will not necessarily recognize the person that you have been living with, so someone that you are not legally married to. It will be impossible to leave certain items or to specific family members. And your estate could face substantial claims from an ex-spouse or children unless you have provided for their maintenance in a validly drafted and executed will. And once again, your children will only inherit at 18 years of age. Right, we'll be looking at three scenarios. The first scenario when it comes to interstate succession is where you have a spouse, but you have no children. So in this example, Mr. A died with no descendants, but with a surviving spouse B and his parents. His estate is valued at 800,000 Rand. Mr. A died without having a valid will at the time of his death. How will his estate be distributed? Well, in accordance with one of the first rules in the Act, B, his surviving spouse, will inherit his entire interstate estate. The second scenario, where Mr. A dies and he has no spouse, but he has children. So Mr. A dies and he is survived by his two children, C and E. He also has a predeceased child, D, who was survived by two children, F and G. His estate is valued at 840,000 Rand. Mr. A did not have a will at the time of his death. The question is, how will his estate be distributed? In this instance, the descendants will inherit everything with representation by stirpies. So a stirpies is what you would see in the diagram illustrated by a branch with the arrows. So in terms of D, his predeceased child, D, predeceased means obviously died before him, is survived by two children, F and G. So F and G would inherit in the place of D per stirps, 140,000 Rand each. Okay. So that is D's 280,000 Rand divided by 2. Okay. Scenario 3, where Mr. A dies and he has a spouse as well as descendants. So Mr. A dies this time with an estate value of 850,000 Rand. He leaves a spouse B and children C, D, and E. He didn't have a will at the time of his death. How will his estate be distributed? This is where we would need to calculate a child share, or the Interstate Succession Act defines a child share as all of the, adding all the children plus any predeceased children to the surviving spouses. So in this example, we have One spouse, 3 children. Okay. The spouse, B, would inherit the greater of what we've calculated a child share, or 250,000 Rand. The child share, just to recap, the child share is calculated by dividing 850,000 by the 4 people, spouse B plus the 3 children. In this example, the spouse would inherit 250,000 Rand, as the calculated child share is less than 250,000 Rand. So she or he would inherit 250,000 Rand. And the children would inherit the rest, which is C, D, and E, 200,000 Rand each. If D was predeceased, his children would inherit per stirpes. All right, so what does this tell you? The main takeaway from this is that many people say they don't need a will, as they still have small kids, small children, and they don't have a lot of assets, and that their surviving partner or spouse inherits everything. The Interstate Succession Act has very clear rules on how a person's estate will be divided if you don't have a will. So it does make sense to rather exercise your right to leave your assets to the people who you want to leave it to. What about the matrimonial property regimes applicable? How you were married? The 3 marital regimes in South Africa. We have in community of property marriages, which is where each person in the marriage has an undivided half share of the joint estate. So if the marriage, and remember, a marriage can only be dissolved by death or by divorce, 50% automatically is owned by the surviving spouse, and the person who's died can only deal with the person who's making the will can only deal with their remaining 50% in their will. Where there is no will, the 50% will devolve in terms of the law of interstate succession. When you are married out of community of property without the accrual system, you basically have 2 separate estates. And on death, each spouse can deal with his or her estate without any restrictions. A portion does not automatically accrue to the surviving spouse, like you have within community of property marriages. Out of community of property, including the accrual system, when the marriage comes to an end, the estate values are determined separately, and the estate that shows the greatest growth over the duration of the marriage must pay the other estate half of the net accrual. So that sounds quite complicated, but it is something that the executor would do on death to determine what the accrual would be in the deceased estate. All right, so what can you do to ensure that all your affairs are in order? To achieve efficient estate administration, to appoint heirs or legacies of your choice. A legatee is someone who inherits a specific item from your estate or from your will. To provide liquidity in your estate, this is basically the aspects of estate planning. To provide for your dependents and protect minor beneficiaries. To minimize the impact of taxation in your estate. To provide for future growth of assets outside of your estate. To provide for succession planning when it comes to business interests. To minimize costs overall and to ensure that the plan is both practical, legal, and efficient. This is a topic that I deal with on a daily basis, and it is liquidity. Liquidity is one of the main reasons it takes estates longer to be wound up than necessary. Liquidity is what we refer to as the cash needed to settle debt, to pay tax, to make provision for the executor's fees that they charge, as well as the master's office fees, and to cater for your deathbed and funeral expenses. The types of funding for beneficiaries, you can look at liquidity in the form of life insurance that is paid directly to beneficiaries, and then also to avoid selling valuable assets to create liquidity. The short-term funding could also be, for example, an immediate needs benefit, where beneficiaries can claim a certain amount of money from a policy to tie them over while the estate is being wound up. And then one of the important considerations when it comes to a marriage in community of property is that you should ideally not just have one bank account, because on death, that bank account will be frozen for a period of time. Okay. The importance of life insurance. Life insurance gives you an affordable way to provide for your children and your partner or spouse. Can also provide for your children's education. It can help to settle debt. It can help for future expenses. It can help to pay estate duty and taxes that need to be reviewed on an ongoing basis as your estate changes. And you also need to know how much is enough, and that is the job of an estate planner like myself. How much is enough to cover all of these important aspects in your estate? So when it comes to liquidity and life insurance, it usually depends on debt, how to eliminate debt in your estate, and the extent that your financial dependents need support if you were no longer there. Possible sources of provision. If you are employed, you could have access to group life benefits, which could come in the form of a lump sum payable, a lump sum life group life policy. Retirement savings. You could be a member of a retirement annuity or a member of a pension fund through your employer or provident fund. And with retirement savings, there is legislation that deals with who your dependents would be, who would eventually receive the proceeds of a retirement fund. You can look at your discretionary savings as well as your surviving spouse's pension. For example, in the government employee pension fund, it's a public fund, and it provides for a spouse's pension if you meet certain criteria, and you can choose to leave your spouse 50% or 75% of your pension should you pass away. Right. How do you know if you have group life benefits? Well, that would require you to inspect your payslip, look at annual employee benefit statements, as well as looking at policy schedules, because there's usually an insurer that underwrites the group life benefits. All right. One of the very important aspects of benefits, group life benefits, as well as other insurance benefits, is that you should review your beneficiary nominations regularly. Make sure that they are reflecting correctly. Make sure that if you have an estate plan, that it is in line with your estate plan. And also to understand how a beneficiary nomination works in the context of the policy. Because one of the things that's important is that your beneficiary nomination on your policy will override any clause that you have in your will that aims to deal with that policy payout. For example, if I have a life policy payable to my daughter, the life policy is a contract that I've entered into while I'm alive between myself and the insurer. The insurer then purports to pay the proceeds of the policy to my daughter should I pass away. She then, if provided that she is still the nominated beneficiary on my death, she can claim the proceeds of that policy on my death. That policy will not form part of my estate, hence I will not necessarily need to refer to it in my last will and testament because it is not going to be dealt with by my executor. It is going to be a transaction between the insurer and my daughter in the event of my death. All right, so lastly, I would like to just give you a few takeaway points or tips for life and death. Get a will. Make sure that you have a will so that you do not leave your loved ones with a complicated estate or process. Make sure that you review your will at least annually or whenever you have a circumstance that changes in your life or a big life event like having a child or getting divorced, getting remarried, etc. Review your beneficiaries on all your life policies annually, and that includes your group life benefits. Review the value of your life policies annually. It's not always the case that you need more life cover. In my day-to-day job, there are many instances where there could be a cause for reduction in life cover if it's no longer required at a particular life stage. Make sure that your dependents have enough liquidity. So is there perhaps an emergency cash savings available to them to tide them over? Minimizing your estate duty, capital gains tax, and executor's fees. The ways to minimize taxes is to have an estate planner calculate what your estate duty liabilities or capital gains tax liabilities would be, and to then implement strategies to reduce your tax payable. It's not a tax avoidance measure. It is a way to make sure that your beneficiaries, your heirs, have, get the maximum value out of your estate possible. And then you can, as I referred to at a previous slide, also negotiate with your executor in terms of an upfront fee. Most executors would provide a concession depending on the value of your estate. Keep your files in order. Keep a payment reference file for all of your regular payments and due dates. Keep your surviving spouse informed. Keep a deed box with all your important documents. Encourage your family and close friends to do the same and embrace life. Just on that note, in terms of keeping important documents, make sure that your original last will and testament is held in a safe place, because it is that original document that needs to be reported to the master's office. I also recommend, if you have a financial advisor, introduce your children, your spouse to them, so that they know who to approach should anything happen to you. And make sure that they know if you have a will and where the will is stored. All right. That brings me to the end of this lecture. We will now deal with any questions you may have.
Thanks, Tamsyn. I think real serious stuff, it's always these issues of stuff we don't want to deal with, but is so critical to actually deal with. I actually just, in a moment, will put up the, when Tamsyn stops sharing, I'll put up the contact details for PPS. I think the moral is that, whilst it's serious stuff that you do need to consider, it's not something that you have to go at alone. I think there is support available, and certainly, contact your accredited financial advisor or contact us at PPS under the Business Connect at PPS address, and we'll get in touch with you. What I'd like to do is just run through some of the questions aligned to what you've just discussed with us, and I just want to get here. Let me stop sharing this for now and bring up the questions. So I think a major point for me that resonates quite strongly is this idea of, we have these two extremes where some individuals say, well, look, I'm dead and gone, I don't care. And others really want to, what we like to say, rule from the grave. And I think realistically, it's not only about having a valid will, but having an executable will. And the first question was, can an individual place restrictions on beneficiaries, as a condition before they can benefit? So if you have an issue with a beneficiary that visits shebeens, has drug gambling problems, etc., how would you control that from a will perspective?
Okay. So yes, dealing with a beneficiary who might not be responsible is something that often comes up in practice, and people need to then decide what to do. One of the things that you can't do is you can't place a restriction on an inheritance if it's an illegal or against what we call against public policy, if it's immoral. So, for example, putting a condition in your will that your daughter may only inherit if she does not get married or stop smoking or other things like that. But when it comes to a beneficiary who might have issues with drugs and addiction, the best way to make sure that they can inherit, that someone can look after them, and is to have a testamentary trust and to nominate trustees, capable trustees, preferably independent trustees, who can then administer that person's finances on their behalf. And in that way, you can provide an income for that person, that beneficiary, and make sure that they don't squander their inheritance in a shebeen. Yeah.
Thanks, Tamsyn. I think, really the key there would be a testamentary trust, but also managing yourself in terms of how much control is reasonable, and where does it become unreasonable or unexecutable. The next question we have is with regard to the marital regimes in particular, and the question is, in the event of a spouse passing, being married in community, out of community with accrual. The surviving spouse has a bigger estate. Does the settlement go according to the will that the deceased had?
In essence, the settlement of the accrual claim. So in this instance, the surviving spouse has the bigger estate. So are we saying that the accrual in their estate was bigger?
Yeah. So essentially, we're saying that the surviving spouse, yes, has the bigger estate. The spouse with the smaller estate is now deceased. And I guess the question is, in terms of the
Yeah.
deceased estate will, how will that play out?
Okay, so firstly, there should then be there will be a liability in the deceased estate. If I'm understanding the question correctly, the person who's passed away has had the surviving spouse has had the bigger estate. But let's talk about the accrual. The accrual is the difference in the end value of the estate, the day that they've passed away, and what they started off with. So when you get married out of community of property with accrual, you sign an antenuptial contract, and in that contract you would state the start values of your estates, your respective start values. You would document if there are any specific assets that you have started the marriage off with that you want to exclude from the accrual. And then once the accrual is, once death occurs, one of you passes away, the accrual is then calculated at that point in time. So if I just go back to this question, let's assume that the surviving spouse has a claim against the deceased person's estate. And that deceased person, the deceased spouse, left their entire estate to that surviving spouse. Technically, yes, the surviving spouse has an accrual claim. They can institute that claim in cash, but they are the sole heir. So it wouldn't make sense for them to institute a cash claim on assets that they are going to receive. I hope that makes sense. So in terms of the will, it does play a role. The will of the both spouses plays a role in terms of whether the accrual claim, as well as the, practically at death, what will happen in terms of the accrual claim.
Yeah, and I think the theme here is really that, it's not just about a will, it's not just about a marital contract. It's about, having sound estate planning, understanding the implications of, marital regimes, marital contracts, knowing estate values, etc. The next question comes up, and it's I think a topic that comes up a lot when dealing with wills, and it's relating to executors. And I've got a lot of individuals that are professionals that have taken on the task of being executors, only to realize that they should have never taken it on their back. So the question here is, does the executor have to be a lawyer?
Okay, so no, the answer is no, the executor does not have to be a lawyer. They can be an attorney or a trust company. They can even be a chartered accountant. But when it comes to the job itself, the administration of the estate, there are instances in which the master's office will consider the appointment of your nominated executor in your will, depending on the complexity of the estate, how much assets there are, because because executorship is such a specialized field. You need to understand the law of succession. You need to be familiar with the Estate Administration Act. You need to be able to deal with all the various third parties like SARS. You need to understand the process. So yes, you can nominate anyone in your will as executor of your estate, but it's possible that the Master of the High Court might insist that you appoint a professional person, that they appoint a professional person to do the actual administration of the estate and the actual work that is required.
Okay, thanks for that. So tying into that question is around costing. So what would be a reasonable fee to pay an executor to close up your estate?
So currently the statutory rate for executors is a fee of 3.5% levied on the gross assets in the estate. So if I have a gross asset base of R1 million, the executor who I've nominated in my will, and who's then been appointed by the master once I've passed away, they could charge that fee plus VAT of 15%. So the total charge could be 4.025% of my gross assets. One of the things that you must consider is what is part of that asset base. The example that I gave about the life policy that's payable outside of my estate going to my daughter directly to her from an insurer, those funds will not be subject to executor's fees. However, my house, unit trust investments, my vehicle are estate assets. Then the Administration of Estates Act does provide protection for people, that an executor can't charge an exorbitant fee if it's not justifiable. So it definitely will depend on the level of work done. So you can also negotiate with your executor upfront. You can your heirs can negotiate with an executor should you not have appointed one in a will. But yeah, there is regulation with regards to executors' fees, and it is advisable to either have it documented in your will, if possible, and agreed with your executor to any concessions, especially if you have a large estate.
So I think the next question ties quite nicely into, liquidity, estate value, asset values, etc. And the question is, at which point during the estate liquidation are the estate taxes due? So the fees that we have to pay to ultimately close up estates, when does that come in, and perhaps how does that process work?
Mm-hmm. So that would happen after the liquidation and distribution account has been drafted and has been approved by the master. And once the executor, obviously, after that, before that even, the executor would have been aware of all the assets that they're dealing with, all the debt that needs to be paid, and then before distribution, the executor would then pay over any taxes that needs to be paid over to SARS. The deceased estate is registered as a taxpayer. So that is one of the things that the executor would need to do before the final step, which is distributing to the heirs.
Okay, so talking about distributing to heirs, we have a question relating to insurance policies, and the question here really is, if your children are on your PPS life cover as beneficiaries, but they are under 18, will the money go to the guardian?
The natural guardian of the child. Okay. As I'm aware, on the PPS policies, there are you can nominate a child as a beneficiary, but we do have a beneficiary fund that can accept that benefit on behalf of a minor child. However, depending on the circumstances as well, I am a firm believer in a testamentary trust for a child because it offers more flexibility and more peace of mind for a parent. So yes, the policy, if you nominated a child as a beneficiary on a policy and you don't have a will, it's likely that the guardian or the guardian's fund, the master's office fund, would accept that benefit in cash, and then it would be administered by the guardian's fund. It won't necessarily be handed over to the natural guardian to without security.
Yeah, and I think really for me, that's one area where you want to try as far as possible to stay away. You do not want inheritance funds to go into the guardian's fund. In terms of the administration of that, even the timelines, etc. Tying into perhaps interstate succession and this idea of leaving a legacy, etc., is, can the heirs, if it is the children of an estate, renounce their inheritance in favor of a surviving spouse?
Yes, in terms of testate succession, meaning you having a will, as well as interstate succession when you don't have a will, there are provisions in both instances, the Wills Act as well as the Interstate Succession Act, that deals with renunciation. So in the Wills Act, and they mirror each other. In the Wills Act, if you, as a descendant, if you renounce your inheritance, Section 2C1 of the Wills Act, it deals with you. If a descendant renounces an inheritance, it will automatically vest in the surviving spouse if there is a surviving spouse. So if I renounce my inheritance, I can, just to answer your question, I can renounce an inheritance, but it will automatically vest in the surviving spouse. So for instance, if I renounce an inheritance that I received from my mother and my father's still alive, that renounced inheritance will then vest in my father.
So keeping with the theme of life insurance, the question we have here is, does a life insurance policy where there is a nominated beneficiary form part of gross assets and is subject to executor fees?
A life policy where there is a
nominated beneficiary.
Yeah, so no, it will not be subject to executor's fees, but it could be subject to estate duty, which is a tax. And these are the two things that are mostly confused in practice, is what is the difference between executor's fees and estate duty. Estate duty is a wealth tax. Executor's fees is what I described earlier as the fee that an executor charges to do the job of winding up an estate.
Okay, so something tying into the issue of executors, and we have two questions, but I guess are under the same theme. It's about, how do you ensure that you get a trustworthy executor, and that an executor actually does fulfill, what's been put in your will? So how would you manage that process?
There are many reputable companies and trust companies out there, professional, that offer professional executorship services. I think in terms of the choice of executor, firstly, make sure that they do executorship as, their regular 9 to 5, that there's no possibility that executor might immigrate, or there's no succession if they pass away, etc. So make sure that you are dealing with a reputable company or trust company who's going to be around. If not, then make provision in your will for alternative executors. Make sure that your executor is based in South Africa if your assets are in South Africa. Make sure that your executor has the necessary knowledge and skills to do the work. Or you can leave it up to your heirs to decide who to nominate as executor on your death. It is an option. It might not always be the best, because dealing with grief and then having to go and source an executor at that point in time could place your family under unnecessary extra stress. But that is an option if you haven't decided who to nominate as in your will.
So keeping with the theme of how to choose an executor, we have a question here that, and I guess somewhat of a comment as well. This individual was advised by their bank that it wouldn't make sense for the bank to act as the executor because the estate was really small. And they recommended that the spouse then apply to the master to be the executor. This was to save the surviving spouse unnecessary costs. Is that acceptable? What should you potentially do in that type of situation?
Okay, so the law provides for an instance where if your estate is less than 250,000 Rand in value, or even less than 50,000 Rand in value, for much less onerous processes to follow. So the master's office might not then require the full executorship process. And that is what is referred to as a letter of appointment that's issued to someone who can be the master's representative. So in that instance, for example, if the only asset to be administered was a vehicle, that's the only asset in your estate, you don't need a fancy executorship process. It's just a matter of, and there's no debt, for example, it's just a matter of transferring that vehicle from the deceased estate to an heir. That can easily be done, and it does not involve, a long, lengthy process. So the law has a process for that is much less onerous and something that the surviving spouse can do. They would then approach the master's office. Well, before they approach the master's office, the professional executor that is nominated in the will renounce their executorship in favor of the surviving spouse. The surviving spouse can then approach the master's office to obtain what we call letters of appointment as a master's representative. And the master's office will then at that stage advise what are the steps to wind up this estate. And if it's just a matter of transferring a vehicle from the estate to a person, that is all that is needed. So there's a lot less detail involved, and there's no executor's fee needed in that instance.
Okay, thanks for that. So last question before we wrap up has once again to deal with policies, and here in particular, if you have a seeded policy, a policy that's seeded to a trust, and you pass away, is that taxable? How would that be viewed?
So a policy on your life, when you mentioned the word taxable, so I think we're talking about estate duty in this instance. Any policy, domestic policy on your life, will form part of your estate for estate duty purposes. There are some exemptions or exclusions, exemptions when it comes to certain business arrangements. But generally, if you have a policy that's seeded to a trust, but the policy is on your life and you pass away, that policy will form part of the property in your estate, what we call deemed property, and will be subject to estate duty at 20% or 25%, depending on the value of your estate. So ideally, you would then need to make provision for the estate duty attributable to that policy, or the cedant, the person who's receiving the funds, would need to pay in a portion of that estate duty. They are effectively.
So tying into that just really quickly as we wrap up, talking about deemed property. So if I have a life policy where I have my wife as a beneficiary, does that form part of my estate? How will it be viewed in the estate?
Okay, so in the estate, yes, it will form part of your deemed property, because any domestic life policy on your life forms part of deemed property. However, any benefit that is going to a surviving spouse, there are certain deductions that the executor can claim in the estate duty calculation, what we refer to as the Section 4Q of the Estate Duty Act, deduction that is going to the surviving spouse. So if that policy forms part of deemed property, say it's R1 million, and it's payable to your wife as beneficiary, that R1 million can qualify as a deduction under Section 4Q. So the net effect in your estate duty calculation is 0. However, any deduction claimed or any deduction claimed can sometimes be thought of as a deferral of estate duty when it comes to other assets. So yeah, that is just something with regards to estate duty. Eventually, there's going to be duty paid unless all of your assets have been transferred into a trust.
Thanks, Tamsyn. I think that was a really clear answer. And I think for me, just in closing, before we formally close the session, it's really about, having a valid and executable will, but also understanding that it's not a once-off, and it's not about the will or estate planning. It's got to talk to each other. And I think life happens. We talk about ex-spouses, children, all of these things happening as we go along. And we really, very rarely take the time to consider what these changes, or how these changes impact us, and our wishes for when we're gone. So that being said, I'd like to close off the PPS piece for tonight's session, and I'd like to hand over to the SADA team just to close us out formally.
Thank you. Thank you, everybody.
Thank you, ladies and gentlemen. We will end the session for tonight.